Hi, hello, this is Dr. Prasad Putilam with the class video series on research methodology and intellectual property rights, Module 3, Part 5. This is the subject code 21RMI56 of Visvesvaraya Technological University, Belagavi, Karnataka, common for all the 5th semester students. So, this particular class video covering this Module 3 syllabus and the main things are highlighted here. Okay, so some technical error. Okay, now it's working. Okay, so this is the syllabus which is indicated here, and it is covering to the course outcome of to know the fundamentals of patent laws and drafting procedure. That is the course outcome given for this particular the given module wise outcome is given for this syllabus. Okay, so that is module 3 is course CO3. Then engineering and research methodology by Dipankar Deba, that is a textbook which is mentioned as the reference material. So you can download that material, reference material from the internet by typing it. So this is the syllabus which I am covering in this particular class video, that is patent infringement, infringement of a patent, literal infringement, equivalence infringement, indirect infringement, defense, experimental research or education, Bolar exemption, government use, patent exhaustion, patent misuse, inequitable conduct. This much made as a group, and made a question based on that, evaluate the various forms of infringement along with the corresponding defenses to provide critical insight into the practical applications, legal proceedings, and potential impacts of these concepts in the area of intellectual property rights. So you mentioned a revised to Bloom's taxonomy level of 4 with covering CO3, and 10 marks is given for this. Okay, so this is the answer key which is the syllabus itself, which I am covering this particular class, the same syllabus. Okay, we'll start with patent infringement. The infringement, the word infringement, it actually shows or refers the violation or unauthorized use of a legal protected right, often related to intellectual property such as patents, copyrights, or trademarks. So in the context of patents, infringement occurs when someone makes, use, sell, or offers for sale a product or process that falls within the scope of the claim of a valid patent without obtaining the necessary permission or license from the patent holder. It is an act that encroaches upon the exclusive rights granted to the patent owner, leading to legal consequences and potential legal action to protect those rights. And there are different forms like literal infringement, equivalent infringement, and indirect infringement. Okay, so it's nothing but when we have a invention which is patented, if anybody is misusing it, anybody is using without the permission, if they are using, then it is called infringement. If we are using, then we say that we are infringing it. Okay, so that is the term infringement. So we'll see one by one what are the three terms. Literal infringement. Okay, again things are written straight away, so I'll read it once. So the literal infringement, it occurs when an accused product or process, it includes all the elements or limitations specified in the claim of a patent. If someone makes, use, sell, or offers for sale a product that exactly matches the language of a patent claim, it constitutes literal infringement. Example is also given if a patented method involves specific steps like step 1, step 2, step 3, like that, say mentioned as A, B, C, 3 steps. If specifically mentioned these are the steps, and a third person performing those exact steps without authorization would be guilty. This infringement is called literal infringement. Okay, so as such, whatever mentioned in that patent, while patenting, as such they are using it. Literally they are using, no change at all. As such they are using. We call it as literal infringement. So imagine if a company X or any company, a company fraud. Okay, it holds. Oh no, a company good. It holds a patent of unique smartphone. with the specific features, including the distinctive the everything is mentioned very perfectly, even the camera placement, what is the screen size exact, and the unlocking mechanism, how it works, everything is perfectly mentioned by the company good or company X. If a company false or company Y releases the smartphone that exactly replicates these features without obtaining the permission or any information or something, any consent from the company good, then it is literally infringement. So that is the meaning of literal infringement. So we'll go to the next one, that is equivalence infringement. Equivalence infringement refers to situations where the accused product or the process, it does not exactly match the language of the patent claims, but performs substantially the same function in a substantially similar way to achieve the same result. Okay, so this concept is based on the doctrine of equivalence, suggesting that a patent holder can assert their rights even if the accused product or process has minor variations. An example would be the patented square-shaped widget and an accused circular-shaped widget that serve the same purpose in similar manner. Okay, so it is like we used to joke some of the engineering projects, because few students, they are very naughty, they don't want to spend their knowledge or time. They used to prepare some of the project, one of the project which we used to laugh for simply use, just not so exactly, but still. So I'm from the coastal area of Karnataka, Mangalore mainly. Okay, here coconuts are there, so climbing coconut needs a machine. Okay, so one set of students will do a project with having a screw tightening on the right side. Okay, they say that this is a patentable project and all, which will work. Somehow you can climb 2-3 times, you can climb it, then everything, all the screw, everything will fall down. Okay, then second set of students, they will make the same coconut climbing machine, but screw on the left side. Okay, so it's not at all patentable work, just for the sake of completion of project, just to get pass mark, or trying to then requesting the project guy to give pass mark and all. This will be doing, but they will not get pass mark for the such things, because the external examiner will come and fire. Okay, so like that. So consider a scenario. Okay, equivalence. This example we cannot quote in exams. So, okay, consider a company, say called X. They are having a patent for a cleaning device. So cleaning device, it uses a special type of brush. They using a special type of brush or bristle. Okay, which is very efficient in the dirt removal. If another company introduces a cleaning machine with a brush but of different size, different shape, then we can say it is a equivalent infringement. Okay, it's a minor variation. Literally they are not using the same thing, but it is equivalent thing they are using, so it comes under the patent infringement. That is called equivalent infringement. Okay, then third, indirect infringement. Indirect infringement, it involves the parties who contribute to or introduce infringement by others. There are two types, that is contributory infringement and introducing infringement. So first one, that is contributing infringement. It provides a component or material to be used in a infringing product and is contributory infringement. Example, supplying a key component of a patented device without authorization. It comes under the contributory infringement. Or some other example, if a company, it manufactures and produces and sells a crucial part of a robot, robotic arm. Okay, it produces and sells the important part which is very much needed for the robotic arm to work. Okay, and they are selling it without the permission of the actual patent holder, who is the company. So it's good company. Okay, so a company, they are simply manufacturing and selling, which is a very important product of a robotic arm, a component of a robotic arm. Without that it will not work. So they are manufacturing and selling it. If the component directly contribute to the infringement of the company patented to the robotic arm, then we can say that it is a contributory infringement. That type of infringement is called contributing, directly contributing, supplying without only, not as such the entire robotic arm, a component, a part of that also, which comes under the patent. That is called contributory infringement. Second one, that is inducting infringement, encouraging or causing another party to infringe a patent. Encouraging, okay, encouraging means you have to use this particular product only, which is supplied by someone else, but who is not actually the patent holder. Okay, so this might involve actively promoting the use of a patented method without the permission. Say company, one company, it produces or they marketing or encouraging a third party manufacturer, not the original one. Third party in the sense of not the company which actually producing the product to which they have patent. Another company, they are marketing that you better you collect it from so and so fraud company, then we can call it as inducing. Okay, so the third party manufacturer, they proceed to use the patented algorithm or something, whatever they stole to do, then we can say it is induced by a company to use the product of another company which is not having the copyright. Then it is called indirect, inducing. They are inducing them, called inducing infringement. Now the defenses in patent infringement. First one, that experiment. The experiment defense allows the use of patented invention for research, development or testing purposes without infringing. Means this is a defense case. Means no need to ask permission from the patent holder if it is a sudden case comes as it. Okay, so they can use for the research or development of testing purpose or without it applies when the use is solely for experimental and non-commercial reason. They are not gaining some income from that. Then I can say that it is a defense, or you can defend it. Okay, so example, a research institution uses a patented process to conduct experiments aimed at involving the efficiency of a certain technology. They want to develop a certain technology and they are using a process which is patented, but they are not they are just experimenting it. They are not marketing it, or they are not getting any income from that. Then it is a defense. So that is comes under experiment. Now research or education, similar to the experimentation, the defense is permitted to use. Defense is permitted in the sense one can use or make use of the patented process or patented product. That is the meaning of the defense here. Okay, so they are using the patentable invention in academic or research setting for non-commercial purpose. So it's so clear, non-commercial purposes that contribute to the public knowledge. Example, a university employs a patented method for educational purposes, teaching students about the underlying principles without commercial intent. Okay, so that is called, so without commercial intent is very important. If any commercial intent comes in that, even if the university publicize that we are using this method and teaching, then also it comes somewhat commercial one, because they are attracting students. If they are collecting fees, if the university is a private university or something like that, if income source comes, then it will not be a defense. Otherwise, sold purely for teaching purpose, to educate the kids, then it is a defense. Then Bolar exemption. Bolar exemption defense. It's a defense common in pharmaceutical industry, which allows the use of a patented invention for developing and obtaining regularly approval for generic drugs, facilitating the timely entry into the market, because some generic because any genetic changes happens. So we already struggled a lot during the COVID-19 that time. So such cases and all, if any process or if anything is already established, is there established means patented one is there, then without asking the permission from the one who patented, people can start producing recognized industry only, not all. Recognized industry or the industry which is given the permission to do so, they can do it. No need of getting legal permission from the. By default it comes. Even if the one who is having the patent, if they legally if they go also, they will get the proper explanation that it is used for this purpose. Okay, so a pharmaceutical company uses a patented drug formula during the development and testing phase of a generic version. Generic version in the sense, so we can say the bacteria, virus, they are genetically they are changing, and that genetical changes our gene, we are not able to defend it. Our resistance mechanism, if not able to defend it, then we need some drug to support that. So drug also should have that genetic modification to defend that new viruses or the microbe. Then government can use without asking. So government use provides a defense when a patented invention is employed for a governmental purpose without the patent owner's authorization, typically for the public welfare reasons. A government agency utilizes a patented technology to address a public health crisis without seeking permission from the patent holder is an example given. So not much explanation needed for that. Patent exhaustion. The doctrine of patent exhaustion limits a patent owner's control over a patented product after an authorized sale. That means once sold, a patent owner cannot control its subsequent use or resale. Example, after selling a patented device to a consumer, the patent owner cannot prevent the consumer from using or reselling it. Okay, that means I have a product which I patented, I am preparing it, I am manufacturing it, I am selling it to someone. Once I sold it and get income from that, then I should not think whether he is selling it or not. If he sells it, I cannot go and argue that it is patented by me, you cannot sell it. It's no, that is not possible. That is patent exhaustion, comes under the patent exhaustion. Now patent misuse. Patent misuse, it is a defense against the infringement, which arises when a patent holder engages in practices beyond the scope of their patent rights, such as anti-competitive behavior. Okay, the example makes it very clear. A patent holder attempts to use their patent to control a market unrelated to the patented technology. Means they are using their technology to block others doing business, or to control others doing business unethically. Then it comes under patent misuse. The next one, it is inequitable conduct. Inequitable conduct refers to the patent applicant's failure to disclose material information to the patent office during the application process, potentially rendering the patent unenforceable. Okay, it's a good joke. A patent applicant intentionally withhold relevant information that, if disclosed, would have led to the denial of the patent application, because he knows that it's not a perfect device, not a patentable device. Some loopholes are there. That loopholes he is hiding and then applying for the patent. Then it is called inequitable conduct. Next, I think it's over. Okay, so that's about this particular class video. It was nice video class for me. Something fun I got from explaining this. Okay, so thank you very much. Those who are not subscribed, please don't forget to subscribe. That is the only way I am getting support from you. Means that is only means support, not only support. That is the only thing I can expect as a increase the subscribers. You know that what is the importance of increasing the subscribers. So my YouTube channel name is My Intuition 4865. My name is Dr. Prasad Pudilam. So once again, wish you a happy day. Thank you very much.